Welcome and thank you for joining us for the Litigation Leaders Webinar Series on IP litigation advocacy. My name is Kevin Long. I'm a partner in Quarles and Brady's Milwaukee office in our litigation group. And I have the easiest job today. I need to talk through a couple of housekeeping items for you and then introduce our great speaker, Kristin Noel, who's going to talk us through IP litigation advocacy. The housekeeping matters are as follows. First, you may access a copy of today's presentation and other forms of materials in the handouts panel of the webinar dashboard. Second, we have muted all phone lines for those dialing in and for participants listening to the audio via computer. So you will not be able to speak. We are in listen-only mode. Third, we'd like you to be aware that the presentation is being recorded and an electronic survey will be emailed to you after the program. And lastly, if you have a question during the presentation, please type your question in the Q&A box located in the upper right corner of the webinar dashboard and submit. The conference host will make sure the speakers receive the message. Every effort will be made to answer questions in the final minutes of our time together. And if we don't get to you within that time period, we'll certainly follow up. Kristin Noel is our partner in our Madison office, and I'm delighted to introduce her today. This Litigation Leaders Webinar Series really came out of a couple of accolades that we were honored to receive in the past year. There's a group called BTI Consulting, and they talk to clients around the country, thousands of different clients, and probably close to hundreds of thousands of different interviews over the years. And they ask for feedback from clients on lawyers that they're working with, and opponents. And they put together data, and at the end of 2018, they named Quarles and Brady to two different lists. The first list, which is particularly applicable today, is they named IP litigation powerhouses. They named 53 law firms in the nation that they viewed as IP litigation powerhouses. Not really they, but the clients that they interviewed. They also named Quarles and Brady's litigation group in general as one of only 37 firms in the country listed as most feared litigation opposing counsel. And we were honored by that. And we wanted to celebrate it, also talk to folks about it, of course, and really highlight some of what we really think of our superstars. And Kristin is certainly one of those in the IP litigation area. Kristin grew up in Milwaukee and is a Phi Beta Kappa graduate of Northwestern University, went on to Northwestern Law School, practiced with a very large firm in the Chicago area, and then made the very wise, we think, decision years ago to join Quarles and Brady's Madison office, and she's been a leader in our IP litigation practice throughout the firm, and particularly in the Madison office since that time. Those of you, and I know we have a distinguished group of participants in the call today, many people are very familiar with IP litigation practice, and you all know that there are probably a half a dozen or so jurisdictions around the country that are really IP litigation hotbeds for various reasons. The Western District of Wisconsin, where Kristin works out of, is one of those, and it's primarily because it's a rocket docket and things move very fast there. She really led the development of our IP litigation function through that practice group and through that venue, rather, and really helped us develop the skills that are necessary to move quickly and to handle technical things in a very, very quick fashion. In the last few years alone, she's tried several cases to verdict. In the last few years alone, she served as lead trial liability counsel, obtaining a $44.1 million and $5.4 million verdicts. She also worked as local counsel, obtaining a $940 million verdict in a trade secrets case that went to trial. She's had multiple defense verdicts, including obtaining a freedom to operate for a company's $11 billion technology. She's particularly skilled at taking complex matters and making them understandable by judges and juries. She's one of certainly the litigation leaders at Quarles and Brady, and there's nobody better to talk to us about IP litigation advocacy. So with that, I will turn it over to Kristin.
Well, thank you, Kevin, and good afternoon to all of our attendees. Today's topic is, of course, IP litigation advocacy. I plan to primarily discuss this in terms of patent litigation, as that's the focus of my practice. But almost all of the substance carries over to other types of IP litigation. We have attendees of what seems to be varying degrees of experience in the area of this presentation, will at points be somewhat high level, but we welcome follow-up questions and discussions after the webinar, even after today. I'd like to start with a little bit of perspective. IP cases, particularly patent cases, tend to have really high stakes. Thus, the lawyers are very experienced and expensive, and generally are provided by their clients all the resources they need to win. Both sides will have well-paid, incredibly highly credentialed experts who will come to the exact opposite conclusion. Only 3 or 4% of patent cases ever go to jury trial. So when they do, they are hard fought. And some really intelligent people on both sides, clients, lawyers, experts, jury consultants, they all think their side should win. And a jury of 6 to 12 lay persons will break that tie. They get to decide highly contested issues, typically about very complex technology, having to apply a complicated set of patent law, none of which they've ever been exposed to. If anyone on the jury panel knows much about patents or has much knowledge about the technology at issue, I guarantee one side or the other is going to strike them from the jury panel with a preemptory strike. So the question is, how does a jury decide? I have 2 main interrelated answers. The first is credibility. By the end of the trial, which team do the jurors trust more? Secondly, juries want to do the correct thing, but left to their own devices, they will do what they perceive to be the fair thing. Accordingly, they will generally rule for the side that gives them a clear, consistent theme that is supported by the evidence and lets them see why it is more fair for them to win. Let's start with credibility. How do you build credibility with the jurors whom you've never met before? This slide is going to be akin to all I need to know I learned in kindergarten. I promise I will not go that far and tell you everything you need to know about patent litigation you learned in kindergarten, but there are some really basic rules to live by. First, be nice to everyone. Of course, everyone is nice to the jury, starting with introductions and voir dire, but take advantage of that time. If you're allowed to ask questions, and judges differ on whether you can, do so. Make eye contact. Don't ignore anyone on the panel. Make them feel involved and important. And of course, everyone's nice to the judge and the court staff. The jurors respect the judge more than anyone else in the room. But you also have to be mindful of being nice to adverse witnesses, to opposing counsel. Don't roll your eyes or gasp or snicker at testimony. Don't make obnoxious speaking objections. And that holds true for your whole team. Your associates, even who aren't at counsel table with you, the jurors watch everything. They figure out who's on whose team by, what documents are passed back and forth a lot. And also, we have to prepare our clients on body language when you're in front of the jury. And this last one is the one that gets broken the most. You got to be nice to your whole team. Jurors watch everything. If you're glaring at your paralegal or your tech support person when there's a technology glitch, and there always is one, or you're angrily passing notes to your associates, the jurors notice. And I've watched them notice this time and time again. Be prepared for everything. Preparedness not only helps you not waste the jury's time, and there will be times that they absolutely feel that the trial's wasting their time, but more importantly, it conveys command of the facts and the issues. You really have to show that you have the record at your fingertips. It gives you a lot of credibility. It also helps you command respect from the judge, and the jury will pick up on that. So it goes without saying, you know where you're going with witnesses and get to the point, do dress rehearsals, mock crosses, etc. but also be very prepared with your exhibits. Your paralegal or technician, if you're not running the exhibits, should have your outline, should know exactly where you're going with the exhibits and be ready to go. Impeachment. Impeachment can be the #1 effective tool to destroy the credibility of an adverse party or expert when they're on the stand. It only works if you're prepared. So for each and every question on cross, you need to have in your outline a citation to the deposition transcript, the date, the page, all the line numbers of the witness's prior testimony on the same issue. You can't waste the court's or the jury's time flipping through transcripts because you know there's somewhere in there's contradictory testimony. Most judges aren't going to let you do it, at least not more than once, and even if they do, you've really destroyed the drama of the moment of impeachment, and you've taken the sting out. For your own witnesses, you know their prior deposition testimony by heart. Prepare them before they get on the stand on exactly how it feels to be impeached, what to do, body language, what to say or not to say, and how you will fix it on redirect. Expert disclosures. Experts can only testify to what they've disclosed in their expert reports. So every question you ask your expert, again, you have to have a notation where in the report or their deposition they previously disclosed their opinion, because if you draw an objection, again, the judge isn't going to let you pour through a 300-page expert report looking for the citation, and he's not going to let your expert testify to it. Be truthful. Deliver on all your promises. Do not say anything in voir dire, certainly not your opening statement, that you cannot deliver on with the evidence. Forecast bad facts. You're going to have to take the bite out and maintain credibility with jurors by being upfront with bad facts. And prepare your witnesses. Don't let your witnesses exaggerate or your experts embellish even their credentials, for example, because you will get caught. Once the jury loses trust in you and your side, you're really on a slippery slope. Be appreciative. Jurors are missing work. These cases typically last at least a week. They go up to 2, 3, 4 weeks. And jurors aren't really exactly paid well to sit there in the box. So they're most likely losing money. They're at least losing time with their family, and they have to sit in the box watching lawyers fight over sometimes what can be boring technology for weeks. So of course, say thank you in voir dire, openings, closings, expressly let them know you value their time and attention, but also do it by your actions. Let them know that you're going through your case as expeditiously as possible. That, circle back to be prepared, but also avoid unnecessary fights and sidebars, get evidence pre-authenticated, and don't be repetitious. The second answer I gave you is use an effective theme. Juries love a good storyline to keep them interested and let them feel confident in their ability to decide the case. If you win them over early, you can almost feel them rooting for you. So there are some classic storylines that we use in IP cases. David versus Goliath is, if you can argue David versus Goliath on the side of David and you have facts to support it, juries love it, but of course you can only use it if you have the facts to support it. I won't read all of these, but I'll note a couple high-level things. As a plaintiff, you often have an upper hand. You generally go first, and you hopefully have a feel-good story about how you've invented something great for society. As a defendant, you typically have to decide, am I going to try to make my client's accused products seem more valuable and better than the patents? Am I going to co-opt the role as the real inventor? I have a better product that is far more advanced than the patent, and that's generally consistent with a non-infringement position, and it can be a feel-good theme for the jury. Or are you going to go after the patent? And your storyline might be, I simply practiced the prior art, so no way can you enforce your patent against me. That's a strong legal position, but effectively you're admitting that you didn't develop anything new. And so you really have to think about how you want to play these storylines and which scenario fits the facts. So no matter what storyline you pick, you need to follow some basic rules. They obviously have to be clear. You have to have a clear, understandable theme. Patent litigators tend to get really wonky and get into the details of patent law or technology, and you really have to take a step back and decide how you're communicating and if you have a clear, understandable theme. To do so, you absolutely have to test them, and by that I do not mean asking another patent litigator if they like it. Run it by your administrative assistant, run it by your spouse, anyone with common sense, because that is, above anything else, what the jury brings to the table, our collective common sense. Obviously, you want your storyline or your theme that a win for you is the most fair for obvious reasons. You want your storyline to be consistent, ideally from discovery through voir dire and closing. Hopefully you've been taking depositions with your themes in mind. You've been preparing your witnesses before they testify with your themes in mind. And the consistency, the jury will get it. And then when you finally do get to argue, it's the best moment in trial, and you close, you hammer that thing home. There's an asterisk on this bullet, and that is because in rare cases, you really have to be prepared to move off your theme. The court may rule on a motion in limine right before trial or, frankly, during trial. For example, you can't make a certain argument because the judge thinks it's not supported by the evidence or it's too prejudicial. Or the judge might rule on a motion in limine excluding key parts of evidence that you need to support your theme. In patent cases where copying is involved, for example, that's a hotly contested issue that can make or break either side's theme. You may also discover in voir dire something about your particular panel and some, not just demographics, but actual experience of some of the jurors. You may feel like you better change your theme, so be prepared to be flexible. Your theme should be tethered to your main claim or defense. A judge isn't going to let you go far down the road of we're just really good guys. If the storyline does not comport with the claim or defense, you got to make it relevant. Most importantly, it's got to be supported by the evidence. Circle back to answer number one, credibility is king. For example, if you're a defendant, your theme can't be, we are the real innovator here. If the documents show in developing your competing product, you bought your competitor's product and you shipped it off to China, and you say, build me one of these just in a different color. The jury will hate you if you open with we're the real innovator, and the evidence is as I said. Finally, you want to anticipate your competitor's theme. Think about where your adversary is going and whether your theme seems credible, stacked up against it, whether the evidence or points you're making to help really help your theme or their theme better. So in all these trials, we have to present IP concepts and technology to a lay jury. And that is sometimes difficult to do. But you're going to start by setting the stage and opening. You're going to describe the technology at issue, obviously, and outline the dispute and give a very short roadmap, but don't go too far into the weeds, but give them some context for why they're going to be hearing evidence, witness after witness, about certain technology. So you're going to need a roadmap, but don't make it too long. Generally speaking, if you are the defendant, you're going to want to make the technology sound as simple and approachable as possible. In contrast, again, generally speaking, not in all cases, the plaintiff, you want to drive home and make the benefits of the technology as approachable and valuable as possible. As the plaintiff, generally, you don't want your technology or invention to seem simple or obvious, because that will hit you in validity, it will hit you again in damages, and it will hit you with the overall fairness test. You're going to use teachers, and I like to call them teachers, your witnesses, to explain the technology. Clients are often your best expert on the technology, and it puts a human face on the debate. Of course, you're going to have hired outside technical experts as well, and jurors need you to have what you'll call as an independent outside expert. I've polled juries before, and I've actually had juries say, well, we decided this because this side had more experts, like literally in number, not even the quality. So you're going to have a hired gun. In every case we have, we always debate, is it better to hire a true subject matter expert, someone who has really worked in the actual field with, this actual accused product, or do you hire a hired gun, a professional testifying expert with a fancier degree, maybe in the general technology, but doesn't have, specific experience in the discrete product at issue, but has testified in dozens of patent cases. We lean towards subject matter experts who have actually worked in the field, or maybe a professor or teacher who's actually taught. Someone ideally who's wrote the book on it is wonderful, but that's somewhat rare. They have more credibility. I will tell you, it is harder to prepare the subject matter expert for deposition and trial. You have to teach them the patent basics, which is not a very approachable subject matter for a lot of people. And, the ins and outs of testifying, which, a hired gun will be very slick and have that all down. But the juries, I find, do pick up on the fact as to who knows what they're talking about and who is the hired gun. Of course, if you're explaining technology, you're going to use visuals. Experts will tell you that people retain something like only 15% of what they only hear, but upwards of 90 or 95% of what they see and hear. And while juries skew a little older, we now live in the social media era, so visuals are all the more important. However, I'm going to caution you, use them very judiciously. Visual aids are grossly overused in patent cases, and trial's not a webinar. It's crucial for developing credibility and telling your storyline, for the witnesses to make eye contact and develop some rapport with the jury, which doesn't always happen when we overuse technology. For all technology, again, you got to be prepared. You need to know how to use it flawlessly. So practice in the actual courtroom you'll be in, lay admissibility or get stipulations ahead of time, have the ability to change it based on objections of court, and always have a backup plan. So the tools, these are the most common one. PowerPoint is in every patent trial. It's often used in connection with the courtroom software like Trial Director. But just remember, you're not paid by the word. Only use a few keywords per slide, because if a jury is reading, the jury will read everything you put on a PowerPoint slide. And if they're reading something really long, they're not listening and engaging with your witness. Mix it up with words or graphics, pictures, symbols, if you can. Animation is great for a case when you can't readily see how the product works. Big pieces of machinery, biotech, we use it. Our last stem cell trial, that was something so the jury can really see what your experts are talking about. One other example, we tried a case where at issue was like this 30,000-pound plastic injection mold machine. And the purported trade secret were features and functions on the inside of the machine when it's functioning. But of course, you can't see that from the outside. So we used animation to show how these features and functions worked while the machines were in operation. I will caution with animation, it's particularly important to take care of admissibility issues early. Juries love physical objects. In that mold case, we also had the 30,000-pound mold, but we had it disassembled. And so while the plaintiffs were saying, you can't see these trade secrets, we said, well, you could buy one of the 100,000 that they've sold around the world and just have it taken apart, and I can point you to all of them right now. And that's what we did, and that was very effective in winning that case. Blow-ups of hot docs, go old school. Still very important. Nothing's better than, crossing the adverse party CEO with their own email and admission that they want to knock off your client's product. Have them authenticate the email, it's theirs, and blow up the admission on every screen in the courtroom. And then there's words, not technology, not visuals. Sometimes it's best to make the jurors visualize for themselves, unencumbered by technology. This is really important in patent cases if you're on the plaintiff side, if the invention is a new way to improve people's lives. Let a witness explain that. We had a jury trial for the inventor of the caption telephone, which sued its main competitor that had sold half the market from them. Caption telephone is just a phone used by a deaf or hard of hearing person that allows them to use whatever residual hearing they have, even if they pick up on just a motion, but also receive real-time text transcriptions. We had the former director of the leading advocacy group for the deaf or hard of hearing community testify as an expert at trial as to what life was like for deaf or hard of hearing people before the invention, how difficult it was for them to communicate with their families and friends, their doctors, to hold a job without being able to use the phone. And then she described the benefits of the caption telephone and how it was life-changing. She did so with tears in her eyes, and as did some of the jurors. So that was incredibly powerful, but it would not have been if we put PowerPoint or technology between her and the jury. Lastly, make your record. Storyline and credibility may win the jury, but you also have to get past a JMAL. And if you're in a patent case, you got to get past the Federal Circuit, which reverses 52% of the time. So make sure you get in all your evidence. We only have a couple minutes left. The last slide is on an effective damages case. The best advice I can give you is designate a damages captain, someone on your team whose job it is from day one to work up and run and try the damages case, and hire an expert early. Many parties simply develop the damages case too late. Hire the right expert. Unlike the liability expert, you can hire a hired gun for damages. They don't need to be experienced with particular technology, but they do need to be experienced in testifying in IP cases. Don't be their very first patent case. Consider local education or residence. It's not a deal breaker, but it can be helpful. And I'll note, arrogance doesn't play well. This tends to be a more prevalent issue with damages versus liability experts. So interview and prepare your witnesses to be confident but not arrogant. Consider who's best for the case and theme. Sometimes a CPA with a local good reputation is preferred to the PhD economist from U of C. And make the damages test relatable. Use real life analogies. The most common damage theory in patent cases is a concept of a reasonable royalty under the Georgia Pacific factors, and typically the best evidence is of a comparable license. That's kind of hard for a jury sometimes to understand until you actually ask them if they've bought or sold a house, and you have to have to get a mortgage, you have to have your house valued, and the bank will then, to value your house, pick out, 4 or 5 comparable houses in the neighborhood where you're buying or selling, and one house might be worth a little bit more because it's got a pool or an extra bathroom, and one house might be worth a little bit less because it's got less square footage. Jurors can lock on and relate to that. Use visuals. You're absolutely going to have to in the damages case, but if you can, mix in graphics or symbols as appropriate. And finally, make your record. Damages cases can be boring, but you got to get in that evidence. Often numbers can be stipulated to and evidence can be stipulated to, but if you've got to go through it and authenticate financials, do what you have to do to make your record. And with that, it's 12:30. I certainly am available to stick around if anyone has sent in any questions.
Thanks, Kristin. I don't believe that we have any questions that came through the system. If others have questions that they like to talk about offline, even just something that's going on with respect to your IP issues presently, Kristin's contact information is at the top of the sheet. And Kristin, why don't you just, your direct line is what number? 608-283?
2615. That's right. 608-283-2615 or kristin.noel@quarles.com.
Thanks so much to everybody. Our next Litigation Leaders Series is going to be on June 13th, 2019, where Patrick Murphy is going to talk about policyholder advocacy strategies for maximizing insurance coverage. Thanks so much for joining us, and thank you, Kristin.
Thank you.